Hello, YouTube. I'm Vince White. I'm an employment attorney, and we're answering publicly posted questions from avo.com, A as in Apple, V as in Victor, V as in Victor, O as in Orange.com. And we have a question here from Corcoran, California. The heading of the question is Need Advice. The body, which I'll read into the record now, is as such. I was verbally sexually harassed. It took the company 2 weeks to start an investigation. After they completed their investigation, they said they can't prove he said anything because it was over the phone, but they want to send him to classes because he should not talk to people that way. I did not agree. What should I do? Okay, so not the simplest question, which might be surprising. Your employer is responding to your complaint and they're taking an action. Now, we can disagree. We can say that that action is not sufficient, and I agree with you. I don't feel that action is sufficient. But if they're taking steps to protect you from further behavior and further comments like that, it may be sufficient for now. Maybe. Now, you don't have to accept that. And the laws in California are pretty strong. So I would probably urge you to schedule a free consultation or two, excuse me, with local attorneys in California, because their local laws can have more teeth even than sometimes the federal laws. So check that out. But in terms of the federal law, they may have met their obligation. And let me stress, I'm only talking about the federal law now. You need to talk to local counsel in California about the state laws. What I would say under the federal law is it may make sense to just start documenting everything, because there's a really good chance this guy is going to retaliate against you. He's going to try to do something to you to get you for making this complaint about him, right? And I want you to be safe. So I would urge you to document everything. Maybe start talking to an employment attorney. My gosh, I start making a video and I start coughing. Start talking to a couple of employment attorneys now so you have someone on deck to call with questions. You don't have to pay them, right? Anybody in this industry should be thrilled to work with you and kind of answer your questions free of charge. If they're trying to charge you for a consultation, I mean, it's legal in most jurisdictions to do that, but to me in this industry, highly questionable. We're in this industry to help people. I still get mean emails from the lady in Georgia who thinks I shouldn't be allowed to say that she shouldn't charge for consultations. I'm going to keep mentioning you, lady. You're not going to change my mind. So that is my recommendation here. I'm sorry that you experienced this. I'm sorry your employer had this lackluster response, but it's not over. You might have additional rights under state law, so you should speak to local counsel in California. And also, you should be documenting everything, because I think there's probably an act of retaliation that might be coming your way that could make your claim even potentially more valuable. So document everything, have an attorney on deck, be ready, stay ready, don't let your guard down. And again, I'm just sorry you have to deal with this. But if this was helpful, like and subscribe. It does help me to help more people just like you. And I will check the comments on the video. If you have any further follow-up questions, I will try to answer those as well. Take care.